it please the court? Your Honors, my name is Paul Nettleton. I'm with Carlton Fields. I'm here representing the appellant and defendant below, Raymond Consul, who has now been substituted by his estate due to his passing during the course of this appeal. Your Honor, by this appeal, we're requesting that this court reverse the judgment under review with directions to enter judgment for the defendant on its settlement defense.
Mr. Nettleton, I'm sorry, did you say you wanted to reserve
I'm
some
sorry,
time?
5 minutes, Your Honor, please. We submit that the trial court here erred in granting the plaintiff's motion for summary judgment and denying the defendant's motion for summary judgment on that settlement defense. And specifically, we submit the trial court erred by accepting the plaintiff's argument that its pre-suit settlement offer to Geico, which was the defendant's insured, was a offer to enter into a unilateral agreement that could be accepted only by Geico's tendering of the policy limits, the $10,000 policy limits, before the expiration of the offer, which was 14 days. For two reasons, we submit the trial court erred and the judgment should be reversed. Number one, this offer was an offer to enter into a bilateral agreement, which could be and was accepted by Geico in unequivocal, unconditional acceptance on the 14th day, the last day it was open. At that moment, a settlement agreement was formed. And by virtue of that, when the tender actually occurred is irrelevant to whether the existence of a settlement agreement exists. In fact, Geico tendered the money that evening and returned and delivered it the following morning when the plaintiff's office was not open. The second reason we submit the judgment should be reversed is because even if this court were to construe that offer as a unilateral settlement offer that required tender within the 14 days, we submit Geico still performed within that 14 days by physically presenting the check at plaintiff's counsel's office at between 7 and 7:15 p.m., that's undisputed, and providing notice to the plaintiff before the offer expired that it was ready, willing, and able to perform and to tender the limits. If I could address the first and primary issue in more detail, and that is the question of whether this offer was bilateral or unilateral. The concepts are pretty easy to state. A bilateral contract offer can be accepted either by return promise or agreement to perform the acts requested in the offer or by actual performance, whereas a unilateral contract offer can only be accepted by performance of what's requested in the offer. The language of the offer itself is determinative. That's it. Your Honor, and in this case, that's the November 26, 2013 letter, two-page letter of settlement offer from the plaintiff's counsel to Geico. And when the court looks at this, you'll see that what was proposed as a settlement agreement here was that the plaintiff would execute a release in favor of the defendant in return for Geico paying or delivering its $10,000 policy limits check. The offer was said to be open for 14 days. The tender or the sending or the payment of the $10,000 limit was not a condition that the offer said had to be performed in order to accept. It was a term of the proposed settlement agreement.
And what language specifically are you relying on to make that assertion? Because reading the language, the way I read it, it seems pretty unilateral. And given Geico's letter, fax letter of December 10th, it seemed like you all understood it to be pretty unilateral, because you say, I am in receipt of your letter dated November 26th, in which you are demanding $10,000 within 14 days from the date of your letter. So it seems as though your understanding at the time was that you got to pay up by the deadline.
Okay, let me first clarify, I'm not Geico, Your Honor. I represent the defendant. But Geico, that was one claims examiner who sent a letter asking for an extension, and we submit one is irrelevant because the court must be constrained to the language of the offer itself. Even if that was her understanding, that does not alter the terms of the actual offer. At best, it's extrinsic evidence which the court could get to only if it found a latent ambiguity within the offer letter itself, which we submit is not there. And in fact, both sides have argued there's no ambiguity. But to the extent there is an ambiguity, both sides have said, as did the trial court, that it would be patent based on the language of the offer itself.
But is that because there's a missing term? A missing term meaning the time at which the check is due, the time of day? Why is it a patent ambiguity rather than a latent ambiguity? On its face, it seems clear what needs to be done, but a scenario has arisen in which doubt has been cast on terms of the agreement.
The operative language of the offer is, please send your $10,000 check payable to Mark, I'm going to butcher his name, Chmielewski, as guardian for Matthew Martin. That's it. This offer will remain open for 14 days from the date of this letter, after which it will be withdrawn. There are offers out there, we see them in the cases, that say you must deliver the check within 14 days by 5 p.m. on the 14th day. This letter doesn't say that. That's not one of the terms of this offer. And there's nothing in this offer that limits it. And it's the language of this offer the court has to focus on. Does it say, in order to accept, you have to provide this check within 14 days by 5 p.m.? None of that language is in there, Your Honor. There's nothing in that. And the fact that there's the use of the word tender is included in the letter is not some magic incantation that suddenly turns this into a unilateral offer. The plaintiff, as did the trial court, relied on a number of cases that involved unilateral contract offers. And if you look at those, every one of them involved language in the offer that said you had to do or perform or tender before a specific deadline. This one does not contain that language. The only place tender is even used in this letter, one time, in one sentence, that has nothing to do with the actual settlement agreement that's being proposed here. It's used after describing a prior release that had been signed by Mr. Martin's father on a prior tender that was determined to be invalid because he didn't have authority to sign it. And it says, I would like to resolve any questions of the legitimacy of the prior release by providing GEICO with an opportunity to tender the bodily injury limits under the above referenced policy. That's the only place tender is used. Legitimizing that prior release is not part of the settlement agreement. The proposed settlement agreement here is to have the plaintiff sign a new, valid, legitimate release, the plaintiff being the court-appointed guardian for the injured party. And so I confess I don't even know what that particular sentence means, but it certainly doesn't mean you have to make a tender within 14 days.
Well, but it says, here's your chance. You sent it to the wrong people in the first place, GEICO. Here's your chance to send it to the right place. So within 14 days, send it to the right place.
It doesn't say that, Judge.
But if you read everything in conjunction, the whole letter in conjunction, it doesn't say, let us know if that's okay. It doesn't say, let us know if you agree. It says, okay, you screwed up. Here's your chance to fix it. Do it within 14 days. And I don't understand what you're relying on in the letter. If we are bound by the four corners of the letter, what are you looking at that suggests otherwise? What specific language?
There's only one reference to this 14 days. It's in the sentence that says this offer will remain open for 14 days, after which it will be withdrawn. It doesn't say you have to make the tender within 14 days. It doesn't say you have to send the check within 14 days. It says the offer for this settlement agreement, which is proposed as, I'll give you a release if you pay me the $10,000 limits. That was the settlement agreement. Those are the terms of the settlement agreement that are being proposed. There's no language that says that has to occur in order for an acceptance to occur or otherwise in this offer letter. And Your Honor, if there's any doubt at all, then we fall back on rules of construction. And for more than 100 years, the rule, as exemplified by the first restatement published in the early 1930s through the current second restatement of contracts, is if there's any doubt whatsoever of whether an offer is intended to be bilateral or unilateral, it should be construed as an offer to enter into a bilateral agreement that can be accepted by return promise or agreement to perform as opposed to actual performance. This court and other Florida courts have recognized the restatement as consistent with Florida law, including on the bilateral, unilateral definitions and so forth that are there. The old Fifth Circuit, applying Florida law, in the Craddock case, applied it to directly this situation, where the question was, it was unclear whether the offer was for a unilateral or bilateral, and said, under rules of construction, including the restatement, it has to be construed as an offer for bilateral. Also, under rule of construction, that you construe ambiguities against the drafter, in this case the plaintiff, you reach the same result. So we submit that if you get to that point thinking it's not absolutely clear, that we think it's clear that it doesn't require. But if there is any doubt, then rules of construction would require the court to still find that it's an offer for a bilateral. It's only if the court were to find this clearly and unambiguously as a unilateral offer that we get to that point. We submit that the Hansen versus Maxfield case from the First District is the closest analogous situation to this case. In that case, Your Honor, the court addressed some of the unilateral contract cases that the plaintiff relies on here, found them distinguishable, not applicable, because the court found the offer contains no language indicating that the conditions must be performed to have an acceptance of the settlement offer. It's the very same situation we have here. There's no language in this offer that says that. In addition, in Hansen, the court found that the insurance company's response to the offer that said, we accept your settlement offer, was an unequivocal, unconditional acceptance. Same here, Geico's response letter on the 14th day was faxed and says, acceptance of demand in response to your demand letter dated November 26th, Geico is agreeing to tender the BI limits of $10,000 as outlined in your demand. Unequivocal, unconditional acceptance, just as in the Hansen case, and also just as in the Hansen case. The plaintiff there was complaining, well, the other terms of the offer required specifically appropriate insurance disclosures, and it was arguing they weren't appropriate, and therefore there was no acceptance. The court said no. That the insurance company's attempt to provide that information to you at the same time as the acceptance was an attempt to perform under the agreement that was already formed. And that's the situation here, too, with Geico's attempts to tender, were its performance under an already formed agreement. So we submit, for that reason, the court should reverse with directions to enter judgment for the defendant. We've also asserted in the alternative, if the court were to decide this is a unilateral offer, that Geico nevertheless accepted by its actions. And specifically, it's undisputed here, under their definition of tender, which requires a physical presentation of the payment, that Geico appeared at plaintiff's counsel's office between 7 and 7:15 with the check in hand. The settlement offer, again, says it's open for 14 days and is not withdrawn until after the 14th day. Doesn't put a time limit in there, like a lot of offers we see in these cases that say 5 p.m. or noon. There was no time limit, so it didn't expire until the next day.
What if they had slipped it underneath, what if the courier had slipped it underneath the door?
I wish he had, Your Honor. I don't think, it was a bank building, I don't think he could get, there were no mail slots and so forth, so that was not possible, so he brought it back the next day. But the fact of the matter is, the fact that the office was closed, that plaintiff's counsel was not there to accept it, does not alter the fact that it was presented. It was there. That's undisputed under the evidence.
You said in a case where there was an attempt at performance on a Saturday, and that didn't win the day for, I presume it was the plaintiff in that case, who wanted to establish that the settlement had not been accepted. Does this case differ a little bit, than that case? If you get to the who has the burden? I mean, does he have the burden to get there before 5? I know that's not the right term, but...
No, Your Honor, because the offer did not say it had to be delivered before 5.
Assuming that this is a unilateral contract and performance is the only means by which it can be accepted, who has the burden? In other words, I would say one thing if there was maybe a covenant of good faith and fair dealing where the other party had stymied the performance of the contract and not facilitated the other party's ability to perform. But here it was just a matter of circumstance.
Correct.
Geico didn't make up its mind until a time at which they could not reach the lawyer's office before normal business hours were over.
Absolutely true, Your Honor. But again, we go back to the terms of the offer itself, which it's the four corners of the offer. It doesn't say you have to be there before 5 o'clock. It says before the end of the 14th day. They were there before the end of the 14th day, and I think the case you might be referring to, we refer to as the Cullen versus Paco case, where the court said that a party who presented payment on a Saturday when the office was closed but within the deadline should not be penalized because the other party's not there to accept it. That is our circumstance, and we think it does apply here. And again, if we get to the question of tender being the operative term, which we don't necessarily agree with, but assuming tender were required here, tender under their definition is a physical presentation. They're trying to conflate tender with payment, and the Rissman case, which we cited, addresses...
I'm sorry, you are already about a minute into your rebuttal time.
Okay, I'll try to wrap it up. The Rissman case, Your Honor, discusses a distinction there, that a tender is the physical presentation under their definition, whereas payment is the acceptance of the tender. They weren't there to accept it, so a payment didn't occur, but the tender still occurred.
By the way, if you want to preserve your time, I think you adequately explained that in the brief. It was
Yes, Your Honor.
well
We'll
stated.
rely on our brief for the other arguments. Thank you.
Good morning, Your Honors. May it please the Court, my name is Kristen Norse. I'm with Kynes, Markman, and Fellman, and we represent the guardian for Mr. Martin in this case. So this case is really governed by what this Court has somewhat recently described the Hornbook tenet of contract law, that a symmetry is needed between an offer and an acceptance in order to establish an enforceable agreement.
Doesn't that usually have to do with the terms of the performance under the contract, not necessarily some sort of, one might say, insignificant or non-material lack of uniformity in the way acceptance and offer, the means of acceptance and offer?
I think actually the case law is clear and has been for some time. The Florida Supreme Court and this Court have described the type of acceptance that must be done as a mirror image and said that it has to be absolute, unconditional, identical with the terms of the offer, and in the mode, place, manner, and time expressly or impliedly required by the offer. So that's the Florida Supreme Court case in Kendall, this Court's opinions in Pena, Rebich.
In other words, it's not just that. In other words, to undermine mirror image uniformity, it doesn't require the acceptance to change the actual terms of performance. In other words, the cases say, well, sure, I'll accept, except, you know what, let me just tweak that performance obligation you've requested.
Right, and we've kind of talked about this in the brief as the sort of no harm, no foul argument that, well, it was close enough. And the cases uniformly, I mean, this case, this Court's opinion in Pena, the trial court found the differentiation wasn't material. This Court said, no, that's not for the court to decide.
What was the differentiation there? Remind me that.
I believe that the differentiation there I had something to do with the release. In a lot of cases, there's a differentiation.
But see, isn't that really actually a term of the performance obligations of the contract itself that don't mirror? In other words, not, well, I told you to, accept it in this particular manner, as opposed to, in the acceptance, changing the performance obligation itself. Like, you know what?
Right.
You offered to buy 50, you offered to sell me 50 widgets at $1. You know what? I accept, only I'd like 60 widgets at 75 cents.
Right, and that's a counter. I mean, and it is both in the manner and in the actual performance, because you have the Rebich case out of this Court, which was a tender that wasn't the next day as was required, but was a couple of weeks later. That's not complying with the terms, and it's the terms of acceptance and the terms that are in the offer itself.
Okay.
So I think if you look at, was this bilateral, unilateral, what did it ask? It said, and I think this is almost verbatim, if you send the check, I send the release, we have a settlement. That's
not what it
unilateral.
actually says. It says, if you accept the offer, There's a separate sentence that...
There's three separate sentences, right? There's the tender sentence, there's the, I'm giving you an opportunity to tender the bodily injury limits. The next sentence, if this offer is accepted, and then at the bottom, please send your $10,000 check. And then there's a sentence, this offer is open for 14 days. And there was really not, I think, as I read it, Geico's argument, or Mr. Consul's argument is, well, it's not all in the same sentence. But there's only an ambiguity if there's another rational and reasonable interpretation. If this offer says, here's how you accept, send the check, tender the check. Here's how long the offer's open, 14 days. Then you have to do it within 14 days.
If an offer says, here's how you accept.
Right.
Show me where in the offer it says this is how you accept it, and that is by tendering a check.
Right. It says, and I would point to two separate sentences. There's the tender sentence up on the last paragraph of the first page. I would like to resolve any question of the legitimacy of the prior release by providing Geico with an opportunity to tender the bodily injury limits. Then it says, if this offer is accepted, I agree to have a release sent containing the same terms as the prior release.
It sounds like the contingent, that the guardian is obligating himself to procure the release if this offer is accepted.
I agree. If he sent the check, then the release had to come back.
Where does it say that that it is the only means by which you can accept the offer is by sending a check?
Well, it says, please send your $10,000 check payable to the guardian. This offer remains open for 14 days. So if you look at the cases, there's been 5 cases that are really discussed. And they talk about, is there a directive, do something, send the check. And then is there a time limit, 14 days. And that's what's determinative. And the Hansen case was not like that at all. There's no time limit in Hansen. It's, I'm prepared to settle if I get this, if I get that, if I get the other thing. Okay, yes, we agree to do all that. So the fact that some of it didn't happen right away, there's no time limit. But here, this is sort of the classic unilateral contract.
There's no time limit for the check. There's a time limit for the expiration of the offer.
Right, and the only way you can accept the offer is by sending the check. That's what the offer says, send the check.
Well, it says
And
those
then I'll
two
do
things.
it.
It says, please send this check payable to Mark Chmielewski.
Right.
But it doesn't say, this is how you accept the offer, does it?
Well,
It says those three things. It says, if you accept, I will procure a release for you. Then it says, please send this check payable to Mark Chmielewski. And then it says, this offer will remain open.
For 14 days. And so what is I think the question is, what is the other reasonable interpretation? Geico's position is, well, we could just send a letter saying, yeah, we'll send you that check. And that's not a reasonable interpretation. I'm sorry?
Isn't the way why is that not reasonable? Isn't that a reasonable way of organizing our affairs in litigation? We say, I'll do this, and then, okay, I'll do this, and then you perform later?
Not under the law on what, when you say your offer is please send a check, then the acceptance of the offer is send the check. And that's pretty uniform among the cases. So the classic unilateral contract is the broker, the real estate broker, right? You find me a buyer, I pay you the commission. So that's what this offer says. There's nothing in here to suggest that it's okay to say I'll send it later, particularly when there is a deadline, particularly when the offer is send the check.
But the deadline, you're not going to agree with me, I'm sure, but is not the deadline attached to the expiration of the offer? It doesn't say, please send the check by this date.
I agree with you that it doesn't say in a single sentence, and I think this is Geico's argument. It doesn't say in a single sentence, send the check by this date. But it says, you accept the offer by sending the check, you have to accept the offer within 10 days, within 14 days. So you can put it in separate sentences. It can't be reasonably interpreted as, why have the deadline if they could just send a letter that says, we'll send that sometime. And then what's the interpretation of what was okay?
Why have a deadline if they could just accept with the letter? Are you telling me that you've never encountered a situation in which there's been an offer on the table that was a bilateral offer that could be accepted by means other than performance, and there wasn't an expiration for the offer?
I'm not going to say, I'm not saying there's a bilateral, I'm not saying that might be the case in a bilateral.
Your argument seems to be that there's no other reasonable way to interpret this.
Correct.
And you said, why have a deadline if they could just accept it with a letter expressing their acceptance? And that sounds to me like you're saying that it's completely unreasonable and unfathomable that there could be a bilateral contract offer with an expiration that doesn't require performance. But I want to know if that's what you think.
I would be more precise in that I can't see a situation where it says, I need you to send a check, and then you could say that any kind of offer. And so I think, yeah, you're right. I can't say that it's bilateral and this and that, but if it says send a check, it's unreasonable to say, and it says this offer's open for 14 days.
But couldn't a check be part of the performance obligations of the, in other words, in exchange for a release, we would require $10,000 and it should be made out to Mr. Chmielewski. Those are the performance obligations of a contract. Then there's an offer acceptance of the contract. Those are two separate things. And here, the appellant is saying they're separate because there's no connection between the deadline and the check. And it's arguable, you're saying that it can't be read this way, but that it's arguable to read it, since they're three separate sentences, is that they're separate things, performance obligations and acceptance method.
I think that the fact that there's a directive is what's critical. If this were like Hansen and it didn't have a directive, it didn't say send, it didn't say tender, it didn't require anything to be done, it just said, here's the terms that I'd like to settle on, that's one thing. But I think the directive is critical. And I think once you get to that directive, and it says send the check, I think under the case law that's been cited, the only possible interpretation is this required action. It's a call to action. And when you do that, then we send back the release. And I think that's what really distinguishes the cases. And they're all different on their specific wording, but when there's a directive, a tender, a send, then that's been held to be unilateral.
But aren't performance obligations usually worded in the verbiage of a directive?
I don't think that offers for performance are. I mean, I think that's the difference. Is it's one thing, the offer might be a full out, terms that say, and if you accept, then we have a contract, and here's what the contract terms are. But here you have a very direct, send this, then we have a settlement. So I think that is critical to the case. I want to also talk about this definition of tender. So the definition of tender has always required that you put it out of your possession, that you no longer maintain control of it. And in fact, Geico's own brief recognizes that tender requires actual production, and its brief also acknowledges at page 30 that an acceptance is operative when you put it out of the offeree's possession. And really the critical fact in this case is at 11:59 on the 14th day, who had the check? Geico had the check. Without relinquishing possession of that check, it did not bind itself to the contract. And so on the 14th day, the offer expires, Geico has the check, there is no binding settlement, and that's the law that the judge properly applied here.
Could you talk about, sorry, Judge.
Two things about that.
Mm-hmm.
One, are you abandoning your argument that the offer ended at 5 o'clock or close of business on the 14th day? Because you just said by midnight, so. Right.
And we know, in my brief, I have not made the argument that there is a term of 5 o'clock. That was an argument made below. I think the intention of the argument below was that if you are going to try to comply with something by hand delivery, then you need to be aware of the foreseeable circumstances that you may not be able to do that after 5. But yes, I think Judge Atkinson's asked if they had slipped that under the door, if they had sent it in the mail under the law, that's relinquishing possession, that is the point of a contract. And that's, I think one of the things you see in these line of cases is we can't bend the rules on this. We can't, sort of add different definitions to tender, because this is literally over a century's worth of Florida law that helps us define the precise point at which a contract is formed when both parties are bound. And when Geico holds that check, they have not bound themselves, so there can't be a binding contract.
On that issue, what about the Cullum case that we discussed with the appellant?
Right. So Cullum, two differences. One was it was a tender by mail, so the argument was, well, it didn't get there in the mail on Saturday when the mail tried to deliver it. So that was a proper tender, even though it didn't get there on time. The second thing, and I think you started to talk a little bit about this, is the burden in that case. It was a landlord who was supposed to get payment by a certain date, and it was his burden to show that it did not come by that date. And he actually said, well, I can't remember if I got it timely or not. Here, the burden's on Geico to show that they strictly complied with the terms of the offer, and at the end of the day, again, they're holding the check. They haven't done what they understood really was required of them. And I do think that you can get to this case directly from the Four Corners, but it is definitely telling that the first response Geico sends on that 14th day at 5:01 is, we're in receipt of your letter demanding $10,000 within 14 days. So the idea that it is ambiguous is really an after-the-fact type of construct.
Now, it seems that both the parties have agreed that if there's an ambiguity, it's patent, not latent.
I would agree with that. I don't see how it could be a latent ambiguity. And both parties really did, kept pushing the judge to enter summary judgment because there really was no disputed fact in this case. So I believe Geico's arguments sort of boil down to this, well, close enough, or, let's have an exception, and that would really undermine all of the law that we have that people rely on every day for contracts. Florida law has always required this strict compliance.
Let me ask, because I looked at the South Fork case. It says to make out of this court, to make an effective tender, the debtor must actually attempt to pay the sums due. Mere offers to pay or declarations that the debtor is willing to pay are not enough. So with that definition, how did Geico not actually attempt to pay the sums due and thus tender the check?
Right, and I'm not familiar with that case, but the rest of the cases that we've cited, the tender, it's not enough if you don't actually get it in the hands, or at least out of your own hands. And so I'm not familiar with the specific facts of that case, but the only definition that Geico cited of an alternate definition of tender where it was enough to say I'm willing to do it, I'm ready to do it, was in the equity context. And in that context, it's specifically been limited to that. So all of the other cases that we've cited are you don't tender unless you either actual production and deliver, or you get it at least out of your own possession.
So taping it to the door would have been good?
I think taping it to the door, yes.
Is there
Slipping
no
it under the
spot?
door certainly would be. Taping it, I'm not sure I would have done, but out of your possession, yes. You cannot walk away with the check. And the Florida Supreme Court in Kendall said an offer, it's not an acceptance if it's still in your breast pocket, and that's basically the situation at the end of the day.
Well, it wasn't in his breast pocket on his way there. It was in his breast pocket or whatever after he showed up at the doorstep and nobody was there to accept it.
Right, but that's just a foreseeable consequence of trying to tender after 5 o'clock. And
I'd love to work in that law office.
I would too. I would too. Yes, I mean, that's just a foreseeable consequence. I mean, back before e-filing, which, was a long time ago, it wasn't enough that I tried to come to the courthouse and file a document after 5 o'clock. I had to get it there. And the cases pretty uniformly are the same with tender. If you're going to try hand delivery, then you need to get it there. If you're going to send it in the mail, whatever it takes to get it out of your possession. But I think the one thing that no case supports is you walk away with the check, because that means that after midnight on that night, Geico still hadn't bound itself. Geico could decide not to deliver that check. Geico could decide to send a counteroffer, walk away with the check. You have not delivered it, then it is not a tender. And so the trial court properly ruled that there really was no binding contract, because at the end of the day, that was the conclusion. Geico had control of the check. Thank you, Your Honors.
Thank you, Ms. Morse.
Thank you, Your Honor. Plaintiff's entire argument assumes that this is a unilateral contract. They say, I got to say, 20-plus times in their brief, we've heard it today, that this offer required tendering of the policy limits before the offer expired on the 14th day. The letter does not say that. It just simply does not say that. And that's the bottom line. And I would submit that despite more than a dozen motions and briefing and extensive record that was created below, this court needs to only look at these two documents to decide this case, the offer and the acceptance.
Appellee has said that the fact that there was a directive in the offer indicates that must be the method of acceptance.
Your Honor, there's always directives in any terms of a settlement. You settle cases every day that say you're going to pay or you're going to deliver to me or whatever the language is, but you're going to pay X dollars. Sometimes it even includes a time frame. You're going to pay it by this date, which doesn't mean that necessarily is not a term of the offer as opposed to a condition for acceptance. It has to be clear on its face that the only way you can accept this is by tendering within a certain time. In that case, it's a unilateral contract, or a unilateral contract offer, and this offer does not contain any language like that. Moving on to, let's assume it is a unilateral contract offer, counsel said that it wasn't effective unless we lost possession, lost control of the check. I would submit to you that that's not the law, Your Honor. She's referring to what the deposit mail rule and the rationale behind that. If you look at the Morrison case from this court, it actually rejected that entire line of cases that says out of control is the crucial factor underlying that rule. And it says, no, the actual reason for that rule is that you have to have a manifestation, you have to end sometime. There has to be a formation of a contract. And somebody's not going to know the other side accepted or not accepted, so you got to draw the line somewhere. Corbett on contracts and various other people said that's when you deposit in the mail. There are a line of cases that say that that's justified by a loss of control. Another line of cases came out that said, well, the postal regulations changed, and you can actually control the delivery of that now. And so that rule shouldn't apply anymore. That was what Morrison dealt with, and this court rejected that argument, rejected those cases, and said, no, it's the manifestation of intent. And that's what we have here. There's no question that GEICO manifested its intent to accept this offer by its letter saying it was accepting the offer and by its attempt to deliver. And Your Honor, you mentioned the attempt of delivery. The Rissman case, and I didn't hear the case that you referenced, but the Rissman case that we cited has similar language in it. In that case, it found there was no tender because there was no attempt to deliver. Here, again, there was an attempt to deliver. And so we think, even if a tender were required, and we don't think it was, that there was a tender here.
And Mr. Nettleton, you are out of time.
All right, thank you, Your Honor. Again, we'd request the court reverse the directions and our judgment for the defendant. Thank you.